Thanks very much, and thanks to all of you for dialing and logging in today to have what we hope will be an interesting and informative discussion about what's been happening lately in patent litigation involving the financial services sector, which with a particular emphasis on the Section 101 issues, which I'm sure, as people know, have really come to the forefront in this litigation. We have a great group today. Steve Baskin, who's one of the leaders of our patent litigation practice and expert patent litigator and the leader of our DC patent litigation practice. Dara Karlanchik and Paul Hughes, both of whom are senior associates who work very, very frequently on IP matters, including a lot of matters recently raising Section 101 issues. We have, if you look at your screen in the lower right-hand corner, there's a chat function that allows you to submit questions. We're not going to have oral questions at the end, but if you submit questions as they occur to you, we'll try to handle them in real time or obviously get back to you after the program is over. Finally, the all-important CLE information. Remember that you have to record the secret number that we will be telling you on your CLE form at the end of the program, so be sure to listen for that number and jot it down so that you can record it and get the all-important CLE credit. And with that, I'll turn things over to Steve.
All right, thanks, Andy. Again, welcome everyone. We appreciate everyone participating on the seminar today. The first slide provides an overview of what we're going to talk about today. And you know, I think most everyone has, you know, with Bilski, Mayo, and Alice as the Supreme Court precedent dealing with 101 issues. And since Alice, there's been a fair amount of development in terms of additional subsequent cases that have, you know, now taken Alice and are interpreting it and applying it practically at the district court level. So we'll talk about the background there a little bit, get through that quickly, and then and talk about, you know, what we anticipate seeing as we kind of continue to maneuver through this the 101 issue. The next part, the CBMs and data treasury history. So this group that's with you this morning we've spoken a lot on 101 issues. We've spoken a fair amount on CBMs. The data treasury piece we found particularly interesting. And for those that on the call, and I know there are some that not only have knowledge of data treasury but lived through it, was really a patent litigation cases that I'm not sure if the financial services industry and other industries were impacted as well, like the insurance industry and even others, we'll see again anytime soon. And that's in large part due to the CBM proceedings that have been enacted and other types of proceedings like IPRs. And the interesting thing with the data treasury case that we're going to talk about is the CBM process really started getting traction through the patent litigation matters that data treasury had filed against pretty much every financial institution, you know, dating back to the early 2000s. And we'll talk about that, we'll talk about that progression and how that unfolded. Because it's very interesting. It's not just from a judicial level, but obviously CBMs was something that has been implemented statutorily, but that process is very interesting in addition to just the litigations in data treasury. And we'll talk about, you know, what really came to fold just a few weeks ago, where the PTAB, through a CBM proceeding, invalidated the data treasury patents, and we put down vindication there. Some may describe it as you know, confirming kind of what we already knew 5 or maybe even longer years ago. Some that were living it may say too little, too late, but I think still feel vindicated that, you know, what we believed years ago, that these patents were not valid for a variety of reasons, has now actually come to fruition. And finally, we'll talk about some additional relevant federal cases and the impact that DataTreasury, the decision, has had for financial institutions and related industries like insurance, you know, moving forward, and how, as practitioners, you know, inside counsel, how you'll, you know, be able to manage that and review the issues, and then working with your outside counsel as well. And also we'll share how we will be analyzing it for our clients and moving forward as this law develops. Next, I'm going to hand it off. We're going to talk now on 35, on Section 101. I'm going to hand it off to Andy to give some background on that.
Yes, just a brief refresher on what's been happening in the 101 area. As people will recall, we've really had a trilogy of Supreme Court decisions over the last couple of years that have focused on 101, and in each of which the court has held the claim patent ineligible under 101. Bilski, if you recall, was about risk hedging, and the court said patent ineligible abstract idea. Mayo was about drug calibration, patent ineligible law of nature. Alice, the shorthand, Bilski on a computer, credit intermediation, another economic technique, and the court said simply taking that technique and characterize the claim as saying do it on a computer was not enough to render the claim patent eligible under Section 101. So as a result of these decisions, we've really gotten from the Supreme Court a two-step framework. In question one, is the claim directed to a patent ineligible idea, principally in these cases an abstract idea or a law of nature or a physical phenomenon? And if it is so directed, is there something more, the court has said, that transforms what would otherwise be patent ineligible into something that's patent eligible? And the court has used a lot of language to describe this. Something more, something significantly more is one, an inventive concept is another. And then the court has said some things that don't qualify, limiting the claim to a particular technological environment, such as a computer, not sufficient, and adding, as the court has put it, well understood routine or conventional activity, also not sufficient. And the court has given one clue, which is what's the preemptive effect of the significantly more that the patentee is pointing to? Would the claim basically cover lots and lots of applications of the abstract idea, or a relatively small slice of the possible applications of the abstract idea? And I would add one other concept. In looking at preemption, one question I think that certainly the lower courts have been thinking about recently is, in analyzing preemption, is the something more that's added something that really just takes a universe and segregates it into 4 or 6 or 10 parts. In other words, just saying credit intermediation in some particular industry isn't going to work, because the court is going to say, well, that just means if you have 10 industry segments, you can sort of preempt the entire field. Or saying, you know, dealing with risk during the day but not at night, also not going to work. So I think preemptive effect has an additional kind of limitation on it that we'll be talking about. The other thing I think that's worth talking about is the Supreme Court in these 3 cases was really presented with claims that I think most people would agree are on one side of the spectrum in terms of whether they're patent ineligible or not. They were quite broad, and there really wasn't very much more that even the patentee could point to. But obviously, the lower courts are now grappling with applying this framework in much more complex space. And they're grappling with it quite a lot, as this chart shows. Lots of Section 101 issues arising, lots of claims held invalid. And this is not just in the judicial proceedings, same thing at PTAB. Lots of claims relating to Section 101. So lots of opportunities for courts to grapple with this and take the Supreme Court's guidance, which, as I say, arises in cases that might be on the relatively easy side of the spectrum, and start applying them in cases that are much closer, and that's really what we want to talk about today. Dara?
So I'm going to give you a little bit of background on the covered business method review. I know that some of you have that, but just as some introduction. For a patent to be eligible for a CBM review before the board, it must relate to financial service or product, and it claims a method or apparatus that the process data or claim assist in the operation of that service or product. The exception to this is if it relates to a technological invention, then the patent will not qualify for the CBM review. The reason for this exception is because the goal of the CBM process is to focus more on business processes and generic software-related patents. So if the inventive concept of the patent is truly technology-based, then the patent doesn't fall into those categories and the board does not have jurisdiction for the CBM review. The legislature, when it was developing the AIA, indicated that it intended for the financial product or service to be interpreted broadly. And in fact, the board has followed that and it has been interpreted very broadly as patents have been brought to it for review. We found that when instituting CBM review, the board has found that most things that have some portion of a financial or economic component have been deemed to be a financial product or service for the CBM review, which resulted in the board asserting its jurisdiction over a wide range of patents, including those related to online sales, marketing, and advertising. Since it's usually pretty clear how functions relating to banking systems are a financial service, it's been fairly common for the board to find patents in the banking field to be under its jurisdiction for the review. I'll also note that this is a sunset provision, and so these CBM reviews are available only until September 16, 2020 under the current legislation. The technological invention exception, specifically, as I mentioned, is there to make sure that the CBM review stays focused on financial services because it's not designed to address novel technological features that solve a technical problem using a technical solution. If there's no jurisdiction for the board to institute the CBM review, then the parties can consider another option, such as filing an IPR, but something to consider is the different estoppels that will apply in that case. The patent trial practice guidelines have provided a few examples of technological, some language that does not meet the technological invention exception, and that includes reciting known technologies in the claims, reciting the use of known prior art technologies in the claims, or combining prior art structures where the combination achieves a predictable result. None of those will qualify under the technological invention and get a patent out of jurisdiction for CBM review. And on the following slide, we have a few examples where the patents did not qualify for the technology exception and were therefore eligible for CBM review. In these examples, you can see that though a computer or other automated system may have been a part of the claims, the technology cited was routine and was not core to what the patent owners claimed were the inventive concepts in those patents. So merely automating a process or providing a general description of managing or generating data without more specifics regarding the technology did not qualify as solving a technical problem using a technical solution, and therefore the technological invention exception didn't apply. So with that background in mind, I'll turn it over to Steve, who will give you more information about the DataTreasury background itself.
All right, thanks, Dara. Okay, so one of the main reasons why we thought this would be a helpful seminar, especially for folks in the financial services industry, is the fairly recent decision from the PTAB and the DataTreasury cases. There's a long history of DataTreasury. We'll get into a little bit of the company background, but I think for most that are dealing with patent infringement matters currently, the story that Claudio Ballard and DataTreasury was telling back in the late 90s, early 2000s, you'll see is fairly familiar now and not uncommon. And back then, it was kind of something that was, started this, I'll call it cottage industry of patent trolls and non-practicing entities. The Ballard patents we'll talk a little bit about as well. Ballard obviously coming from the inventor, Claudio Ballard. It's the 988 and the 137 patent. At a very basic level, the Ballard patents cover check imaging technology. So something that the financial institutions now and certainly back then were involved in, and in many respects, the positions set forth in the district court cases were that the financial institutions that were now being sued have been doing this long before Mr. Ballard's patents. And we'll get into just a little bit of the nuances as it relates to the patents in a few slides coming up. The re-exam proceeding, so there were a number of district court cases that were filed, and saying there were a number is a significant understatement. There were 20, 30, 40 cases that were filed against financial institutions in the early 2000s. They were litigated aggressively. They were highly contentious. The re-examination proceeding is something that we'll talk about, and I find very interesting in the sense that, back then there was the re-examination proceeding that was available to, in this instance, the financial institutions. It was limited to this. It wasn't, we didn't have the IPRs, we didn't have the CBMs we have now, and so the re-exam proceeding was very one-sided after the petition was filed, and one-sided in the sense that the patent owner really had, was the only individual able to, and his or her team was able to communicate with the PTO as it related to that proceeding, and we'll talk a little bit about that. The settlements and licensing, and we'll get into the one case that actually went to trial and the result of that, and we'll provide some additional background there as well. So who is DataTreasury? Who is Claudio Ballard? Claudio Ballard, Melville, New York, founded DataTreasury in '98. If you ask Mr. Ballard, and we did, he, claimed to be a prolific inventor in this technology, had a long history of working, with databases, was an early reseller of Oracle products in the '80s, and his big, I'll call it, selling point, when he was deposed and in the one instance where he actually testified at trial, is that he was an expert at systems integration. So he admittedly took what was already out there, but was able to put it all together in a way that no one else could or did, and that's the inventive concept that can be found in the Ballard patents. And his prime example of an analogy is Thomas Edison and the light bulb, that all those materials were out there, and Thomas Edison put them together to create the light bulb. I'm not giving any credence to that, certainly, but that's something that Mr. Ballard testified to, and whether that had an impact on the jury or not, who knows. But that in essence is Claudio Ballard. He's not someone who is really a prolific inventor. DataTreasury and the cases that were filed in the early 2000s came on the heels of some who may know Ronald Katz, who probably is a little bit more of a credible, prolific inventor, having 50 or so, 60 patents dealing with call center technology and obtaining about $1 billion in licensing fees over more than a decade. But I think the timing for DataTreasury, based on Katz, had a lot of the financial institutions and others that were dealing with DataTreasury on the heels of Katz concerned. And certainly the technology and the systems that were being accused, were central to what the banks and the financial institutions were doing internally and for its customers. So the goals that DataTreasury had that they claimed their goal was to market the technology. They had a prototype, and they've stated in articles that they had as many as 100 employees. I'll give a personal statement. I'm not sure how accurate that is, but they do state that in press articles. And they almost went out of business in 2001. Their story and theme, certainly at trial and throughout the proceedings was that Mr. Ballard talked to certain banks in the early stages of his development of this check system or check imaging technology, and that the banks that were involved in that took control, quote unquote, took control of his invention and stole it, and that's why he nearly went bankrupt. So in terms of the patents themselves, we're talking about two patents. They're both related. They're from the same patent family. They were issued in '99 and 2000, respectively, and again, they cover check imaging technology. There's two aspects to what Mr. Ballard purported the patents covered. I'll call it kind of an internal and an external claims. And the first sub-bullet there in terms of external is a system for remote data acquisition, centralized processing, and storage of the required data. And I'll read for you the other bullet real quick, and then I'll circle back. But in terms of the internal piece, an automated system to manage and store captured electronic and paper transactions from various activities, including banking and consumer applications. So pretty broad. And really, in essence, under both of those, what I'm referring to as external, internal, it was really the capturing of checks and other documents via a scanner, so creating an image, and then transferring that image to another location, and then that image being stored and archived. There's one piece to it as well, to the external, which involves encryption, and that is something that Mr. Ballard, really to the point where even at the CBM proceeding a few weeks ago, the decision that came down, that was his big linchpin in terms of why this fell outside of 101 and also outside of the technological exception that Dara talked about for jurisdiction for CBMs. But real quick on the systems that were involved. So the system for remote data acquisition, the external system, could involve really two things. Could involve branches for banks and a branch sending electronically checks and other documents to the bank's internal, banking center, or central banking center, rather. And that was one aspect of what was accused. And along those lines, also, a lot of the banks had, and that was called remote deposit capture, a lot of the banks had business customers where they weren't affiliated with the bank, but a customer of the bank. And they would, instead of, having the trucks being, with the checks being delivered, they would transfer or, so to speak, the checks and other documents via a secure line, an SSL encrypted line, from their business directly to the bank's processing center. The last part, the internal part, is just what every bank was doing internally, was processing the checks after they had been delivered by trucks or picked up from the lock boxes, and processing those checks through scanners, large pieces of equipment. The information from the checks was stored and then archived. And so that's pretty much what DataTreasury, the patents, purportedly or allegedly covered in the systems that were at issue. The first license in 2002, DataTreasury licensed its imaging system to Bank Hapoalim of Israel. We don't know a lot about that license. We don't know if it was more of a product license. And we assume that it covered the portfolio as well, but the literature and the reports indicate that it was for the end user, and that the e-image vault, which is the DataTreasury system, that may have been a big part of it. In 2002, that's when it all started, so to speak, in terms of the litigation campaign. Here's just an example of the financial institutions that were litigating against DataTreasury. You can multiply, this by 2 or 3 times, and it really covers pretty much every financial institution, that is around and that was around back then. That was of any particular size. They really went after the large financial institutions to start. So how did the financial institutions respond? In large part, I think everyone, the group overall, and there was a joint defense group that was formed, really, it was really insistent that, this technology not only had been around for some time, and certainly before the Ballard patents, but had been used by the financial institutions in some shape or form a decade before, whatever the case may be. And the fact that that Ballard received patents on it, you could use the word offensive, but it certainly was something that the financial institutions were not pleased about, because it was not something that they thought he should have received a patent on. So First Data, in particular, filed a reexamination petition in November 2005 for the PTO to reexamine the DataTreasury patents. I'll note that DataTreasury, Ballard was smart in how he litigated and how he proceeded, primarily in essence of who he retained. He had the Nix, Patterson and Roach law firm out of Texas that had cut their teeth on tobacco litigation and had seen a lot of success there, and kind of was one of the first plaintiffs firms to see that that patent infringement was, I don't know if we'd equate it to tobacco litigation. In essence of it really took off, but I think in the same way, but certainly in a similar sense, they saw it as being something worth their time. He then, when the reexam was filed, retained Abe Hershkovitz, and Abe Hershkovitz was a former director of the Office of Petitions at the USPTO, had been there 27 years, and his main role there was to set policy related to USPTO guidelines, and he oversaw a staff at the PTO that was responsible for, for reviewing about 10,000 petitions a year. And so I mention all that because the process back at this time was very one-sided. Other than the filing of the petition, as I mentioned earlier, DataTreasury really had, the only seat at the table with the PTO. And so you've got examiners and representatives of the Patent Office that are communicating with Claudio Ballard about his purported invention. They're communicating with their litigation counsel, and most importantly, they're communicating with Abe Hershkovitz, and Mr. Hershkovitz is explaining to them why this is a patentable system. So we put all that together, and the Patent Office in 2007 upheld both of the DataTreasury patents and actually allowed additional claims. So the reissue patents included additional claims that were not previously disclosed or issued in the original applications. So now, fast forward, and it picks it back up in the district court litigations, which were in the Eastern District of Texas in front of Judge Folsom, and the DataTreasury patents are now what we refer to as gold-plated patents. They've been through the Patent Office not just once, but they've been through there twice. So that had a tremendous impact on the industry, a tremendous impact on the defendants that were defending against the allegations. And you fast forward a certain amount of time following the Patent Office reissuing the patents, and DataTreasury ends up generating really more than 350, but depending on the reports, but around $350 million in licensing revenue from, that came from the financial services industry. Around these times as well, the financial services industry, in addition to seeking the re-exam, there was a lobbying effort that was taking place, and there were three three senators in particular that were at the forefront. I don't mention Senator Sessions here, but he proposed legislation about a year or two before Senator Kyl did, essentially that would have created a preemption effect to the financial institutions that were currently in litigation involving DataTreasury. He came under a pretty big firestorm for a variety of reasons and backed off. John Kyl in 2009 picked it back up, and he proposed an amendment on that year's patent reform bill that would limit financial institutions' liability for infringing the DataTreasury patents. And so there was no secret really about what the amendment was intended to accomplish. Again, the proposed amendment came under a lot of fire, and specifically the bill stated that the banks would be shielded from having to pay money damages if they infringe on check imaging patents. So that amendment failed. Senator Schumer picked up the cause, so to speak, and proposed a provision as a part of the AIA for singling out data processing patents related to financial services for extra scrutiny from the Patent Office. So this was not a specific preemption, so to speak, for the financial institutions, but it created really what we know today to be the CBM process. And, you know, because of it was the effect or impact was, I'll call it less severe than Senator Kyle's or Senator Sessions, there was more and more support for it, and it ended up being enacted and implemented through the AIA and is what we know now as the CBM process. So I'll mention, you know, in addition, you know, to the licensing revenue the DataTreasury received, there was one case that went to trial, the U.S. Bank case, and the jury awarded damages of $26.6 million, and then also found willful infringement, and the total damages there for just that one case were $53.2 million. So what was next for DataTreasury after that? They had obtained, you know, a number of licenses, again, multi-millions of dollars. They had just won in trial, and so not being content, they filed a second round of lawsuits on May 28, 2013 in the Eastern District of Texas. The suits targeted, you know, banks, but also the payment processing services providers, and also some other third parties that were, at least according to what DataTreasury thought, involved in the check imaging process. It also targeted, I'll call it the kind of the second wave of banks, much more of the smaller regional banks as well. That's right, sorry. So what happened next? Now we've got the AIA, we've got CBMs. We don't, you know, we being financial institutions don't have to go through that re-exam process. We've got 101 that has been developing, and so the banks go ahead and file a petition for CBM review of both patents. They did that on October 25, 2013. On April 29, 2014, the PTAB instituted the CBM review for both patents, and then just a few weeks ago on April 29, 2015, they issued final decisions, kind of coming full circle with going back to the re-exam, going through the legislation process, and the PTAB went ahead and invalidated both of the Ballard patents. So now we're going to get into a little bit of the decision from the PTAB. And one thing I'm going to talk about real quick, then I'm going to hand it off to Dara on the 101, is the technological invention exception. And the board focused on Claim 26 to determine whether the claim recited a novel and unobvious technological feature. And I'll just remind you real quick, so in order to have jurisdiction, in order to have CBM jurisdiction, you have it through, you know, it has to be financially services related, and it also has to fit this technological exception, or does not fit within the technological exception. And in this case, I'll quickly run through it. the PTAB said that this is not a technological invention. It involves a conventional scanner, a conventional algorithm, and then just really the transmission of information. And therefore, it does not fall within the exception. I'll just note quickly that the importance of this is that these features within the DataTreasury patents and what the patents were, what DataTreasury was accusing in terms of the systems, had to do with real core functionality for the financial institutions. And so this is something that I think moving forward, the financial institutions, when trying to answer this question of being able to go to the CBM process and whether this exception would apply, I think this is an indication that the PTAB is leaning, strongly towards the core functionality that the banks face and what they do on a day-to-day basis will not fit within this exception, and that CBM route is likely going to be something that that you can go to. So let me go ahead and now we'll get into the one-on-one analysis. I'm going to hand it off to Dara to talk about that.
Thanks, Steve. So when performing the 101 analysis, the board turned to the test set out in Alice that Andrew described for us earlier. Under the first step of the Alice test, the board first determined that the patents were directed to patent-ineligible subject matter. In this case, the board found the claims were directed to the abstract idea of transferring information from one location to another where the transferred information is unreadable without a secret decoder key. The patent owner pointed to the encryption of data as the patent-eligible concept, that the encryption of data as a security measure differs considerably from a mere mathematical algorithm or a formula, and therefore it shouldn't qualify as an abstract idea. The board differed, however, and found that encryption has been useful for hundreds, if not thousands of years. And even though there are patents directed to encryption out there, the board differentiated from a specific encryption patent, citing that where specific encryption methods and added steps were in patents, it changed the core idea underlying the invention, and in that instance could be eligible for a patent. In contrast, the Ballard patents use generic language in the claims, such as capturing images, managing the transaction data, and collecting the data, and do not require more specific steps than simple encryption. Because of that, they found that it did not move past the idea of an abstract idea. The patent owner also argued that the imaging or scanning of documents is not an abstract idea because it's universally used in business practice. But the board found that simply being used as a business practice does not preclude the finding of an abstract concept. They gave, for example, that risk hedging in Bilski and intermediated settlement in Alice are also routine business practices that were also held as abstract. So after the board determined that the claims in the Ballard patents were directed to patent-ineligible subject matter, it turned to the second part of the Alice test to determine whether there are additional elements in the claims that transform the nature of the claim into a patent-eligible application. In order to do that, the claims need to have an element or a combination of elements that are sufficient to ensure that the patent, in practice, amounts to significantly more than a patent upon the ineligible concept. In this case, more than just transferring information from one location to another where the transferred information is unreadable without that secret decoder key. The board found that the claims contain no meaningful limitations other than generic functionality. Again, that's capturing images, managing transaction data, collecting the data, and they don't provide more. The patent owner admitted that these processes are performed using well-known off-the-shelf technology, and these are routine operations. They're not meaningful or special. As a result, the board found that the claims did not require a particular apparatus to limit the claims in a meaningful way, and so the claims of the patents did not contain eligible subject matter under 101 under the Alice test. While the Alice test is really controlling here, the patent owners made arguments regarding patent eligibility under the machine or transformation test, so the board also addressed that briefly. The patent owner had argued that imaging or scanning documents would transform the paper document into an image or film or into data, and therefore it satisfied the machine or transformation test. The board did not accept this and found that the claims do not result in any transformed articles. Instead, the data is just duplicated, organized, and moved from one place to another. And at insult to injury, it does it using merely generic well-known machines to do it. Thus, the additional review under the machine or transformation test did not change the board's view that the claims do not contain patentable subject matter under 101. In addition to the 101 analysis, the board also did an analysis under 112 first paragraph for written description, specifically relating to the encrypting subsystem identification information portion of the claim. The petitioner submitted the declaration of expert Dr. Peter Alexander, to accompany this and support its arguments for both 101 and 112. And the board put a lot of weight in Dr. Alexander's declaration and agreed with him that there was not sufficient support in the specification for a person of reasonable skill in the art to understand what was meant by encrypting subsystem identification information. And so as a result of that, the board found that all of the claims for the 988 patent and most of the claims in the 137 patent were also in eligible subject matter under 112. Following the decision coming down, of course, everyone wants to know what the next steps are going to be. In order to try to combat this decision, the Data Treasury team has two options. If they wish for a rehearing, that needs to be requested by May 29th of 2015. And if no rehearing is requested, then the appeal to the Federal Circuit would be due by July 1st of 2015. And one other thing to keep an eye on is that these are not the only CBM petitions that had been filed against the Data Treasury patents. There are actually a number of other ones you can see listed here. And what's interesting about these is these have all been filed on other grounds, challenges based on prior art. And so these are additional proceedings that will proceed until the decisions are final. So we'll keep an eye on those and see. It'll be interesting to see how those come out as well. And now I will hand it off to Paul to discuss how else this is affecting district court cases and Federal Circuit cases.
Great, thank you. So to conclude, we're going to talk about two different topics. The first, we're going to briefly look at a couple other cases in the federal courts that are continuing the same kind of trend. And then Andy and I will conclude by talking about a few different questions that we think the Federal Circuit is going to have to address over the next few years and the sorts of things that we're going to be looking for as these new cases come up. So just briefly, we're going to talk about four other cases that continue these trends. The first is a Federal Circuit decision from December 2014. It's Content Extraction and Transmission v. Wells Fargo. There, the Federal Circuit identified a similar sort of claim, data collection, recognition, and storage, as being an abstract idea, and that seems like that's a fairly well-established point at this time. On the second step, though, as to whether or not using a scanner or digitizing device to extract information was well known, the Federal Circuit got a bit of an easy out there because there was an oral argument concession that they were able to point to really resolve that case. So it made the job of the court a little bit easier and gave it a little bit less prescriptive effect in some other cases. The next case was a district court case just recently in April 2015, Shortridge v. Foundation Construction. Again, it identified cataloging labor data as an abstract idea. And one of the innovations here is something that we've started seeing in district court cases where courts are recognizing that merely combining multiple abstract ideas together is not necessarily an out on this first step of the Section 101 analysis, that multiple abstract ideas in combination can still remain abstract. And that's a point that we think is going to have continuing relevance and something that we're going to want to watch for. On step 2, Shortridge did something that we're seeing increasingly happen with increasing frequency that we also think is quite interesting. And that's in order to figure out if the additional claim steps, here was use of particular relational databases, were conventional or well-known, the court cited directly to a 1992 article from a trade publication that describes in fairly broad terms the same kind of use of a relational database. So what we're starting to see is an increasing use of prior art at this second step of the Mayo and Alice test, which we'll talk about in a minute, is something that we're going to want to watch at the Federal Circuit. The last 2 cases are 2 different intellectual ventures cases that were also both decided in April 2015. The first was against Capital One, and there were a variety of different patents that were involved, but one that we thought that was quite interesting, and Capital One, we think, did a very nice job of describing the claims process as effectively basic budgeting. The court really found that, I think, a persuasive framing of the issue. And again, the court said that just mere manipulation or reorganization of data didn't satisfy the second step of adding something significantly more to this abstract idea. What I think is really interesting about the Capital One case, though, and it's similar to what happened here, is that Section 112 also really pointed in that same direction. There was a claim term, interactive interface, and the court found that that wasn't sufficiently definite, so claims were also invalid for the separate Section 112 reason. And the next case, the J.P. Morgan case, also has that same kind of 112 undertone that we think it really works complements the Section 101 analysis. So in the J.P. Morgan case, even though the court decided it on Section 101 grounds, there really was this sort of indefiniteness or lack of specificity in the claim that the court gave voice to. The court said in part that the patent does not describe the nature of the rule, and it went through a whole bunch of other things that the patent didn't do or didn't describe. And even though the decision was couched in 101 terms, we see a lot of 112 motivations popping up. So this is, again, something that we're going to want to watch. So this takes us to the themes that we're going to be looking at in the Federal Circuit as these cases that we've talked about go up on appeal, as other cases get up there, and these are some of the second or third generation questions that the appellate court is going to have to confront following Mayo and Alice. So the first question is just what qualifies as an abstract idea. As Andy noted at the outset, the abstract idea cases the Supreme Court's had in Bilski and Alice seemed to be fairly far on one side of the spectrum. They weren't cases that were all too difficult to decide that there was an abstract idea. Now, though, the courts and the PTAB are having to deal with somewhat more complex concepts and concepts involving multiple ideas. And the question is, how far does the abstract idea concept go? The mode of analysis that we're often seeing in district courts now is they simply describe the underlying process or the idea in plain English and then say, well, then that's an abstract idea. I think there's a good chance that the Federal Circuit is going to want to impose some stricter degree of a test just as to how we sort through what is an abstract idea versus what is something that's a bit more complex and can't be put into that category. The second theme that we think is going to be really quite important at the Federal Circuit is on the second step of the Mayo-Alice test, and that's just how do we understand what is well understood routine and conventional activity, the sorts of things that get disregarded or can't qualify as the something more or something significantly more that's needed to transform the patent eligible abstract idea or law of nature into something that's a patent eligible claim. And we think that the term routine here might be really quite critical because we think that the Federal Circuit is going to want to see this test as something that is a lot more or beyond just being something that's known, or else the test then merges right into sections 102 and 103 and really seems to do something that the Federal Circuit will want to see these as being quite distinct tests. But the question then becomes, in everything but those easy and obvious cases like Bilski and Alice, is expert testimony necessary? We saw that come up in DataTreasury. We've seen that in other district court cases where litigants are truly relying on experts to be able to say what is in fact conventional or routine in the industry. And just how the Federal Circuit calibrates this question is going to have real import for Section 101 cases moving forward.
Yeah, you can see some real questions about slippery slope here with respect to both abstract idea and routine conventional activity. I mean, at bottom, everything is based on an abstract idea in some sense. So if you say we can dig through the claim and find some abstract idea lurking somewhere below it, the first step could be satisfied in almost every patent claim. So there's going to have to be some limit, I think, on what the Federal Circuit is going to allow in terms of how close to the surface, if you will, the abstract idea has to be. And then, as we're about to discuss, what routine and conventional means and how it relates to other parts of the patent law is going to be a really difficult issue, I think, for the courts to grapple with.
Right, so this takes us right to the third theme that Andy says really closely related to the second theme, and it's what's the role of prior art? Because if conventional means anything that's contained in prior art, and we have seen some district courts that seem to go that far, we think the Federal Circuit might have some reservations that really starts merging these tests with 102 and 103. But on the other hand, prior art seems really quite important in the hands of an expert to be able to figure out what routine or conventional really means in this context, such that there's some real substance to those opinions. So we think the Federal Circuit is going to have to do some careful thinking about the proper role that prior art has to play, and how that test comes out really can have some substantial prospective implications for how Section 101 is going to be applying in future cases. And finally, our last theme is the continued importance of Section 112 in this area. As we know, some members of the Federal Circuit have been a bit wary or reluctant with Section 101, and although the Supreme Court has spoken fairly firmly on that point, we still think that Section 112 will provide an opportunity for members of the court who are reluctant to see 101 broaden in some ways that might be of concern to them to still reach similar results and similar motivations for why certain claims are invalid. So when we see 101 questions pop up, as in DataTreasury, litigants are also pursuing parallel 112 arguments, for example, lack of written description. Again, DataTreasury is a pretty good example of how those sorts of arguments work in tangent. The other sort of issue that we're seeing, and we think there'll be a renewed focus on at the Federal Circuit, are functional claiming issues, to the extent that, particularly in the software context, patents claim particular functions but don't provide concrete means with which to accomplish those functions. A relatively recent case, a few years back, Federal Circuit E+ really focused on this issue, saying that claims can't just use a black box element that describe what the outcome is without providing either in the claim or the specification some means for accomplishing it. And there really were two principal reasons the court said that has to be the case. The first is if you don't have those specificity, the preemptive scope of the claim becomes too broad. You can preempt anything under the sun that could lead to that outcome. And the court, in ways that are similar to the preemptive concerns under Section 101, explained how that would really be an improper result. And then the second requirement here, what this effectively accomplishes, is to ensure that the patentee in fact had possession of the invention, that they did invent it because they knew the steps that would go into what would otherwise be this black box result that would lead to the claimed function, that they in fact had the means to be able to accomplish and achieve that.
Great. Well, thanks very much to everybody for those terrific presentations. We've just about reached the end of our hour. We did have a couple of questions. One asked, and I'll rephrase it slightly, for DataTreasury, they won in court. They won in the initial re-exam. How come they got whacked by this CBM proceeding? And obviously, the difference, a couple of reasons. No offensive collateral estoppel. So to the extent there are new parties, those arguments that DataTreasury prevailed on in those proceedings don't bind the new parties who were in some circumstances in court, in some circumstances in administrative proceedings, raising those claims. We had another question about the PowerPoint.
Yeah, that's fine. If this is Steve asking if We will, if you note while we're still in the presentation, if you would like a PowerPoint to be sent to you, we can have that sent to you. And feel free to email me at sbaskin@mayorbrown.com if you would like the copy of the PowerPoint, and we'll send that over to you. One additional thing just to note real quick on the dichotomy between the district court decision and the PTO. Typically, the PTO, parties may argue that certain deference should be provided, but they do their own independent review in particular in situations like this. And also, with from the U.S. Bank trial and the cases that preceded that, the law has developed so much since then that I think DataTreasury would have a hard time, arguing collateral estoppel in that context.
And with that, thanks very much for joining us.